Hello, welcome to this information webinar on the Personal Property Securities Register. How do you, as a small medium enterprise operator, protect your business? I'm Peter Towers, Managing Director of ESS Small Business and ESS BIZTOOls. Well, you might start off by asking, why worry? Well, the problem is that millions of dollars have already been lost by Australian businesses, primarily through ignorance of the operations of the Personal Property Securities Act and the associated register. Over $400 million, in fact, in court cases and in out-of-court settlements and in forfeited assets. This is a huge problem for businesses. It's a time bomb for businesses. If you haven't been involved at all in the Personal Property Securities Act or the register at this stage, then all I can suggest to you is you've been lucky. A lot of businesses have been caught, both very small and large businesses. In fact, a subsidiary of one of the largest corporate groups in the world was caught for around $65 million through the non-registration of an asset. So what is the problem? Businesses are losing assets through ignorance of the law. Wide range of activities have been affected. Motor vehicles and trailers have been lost. Cleaning equipment and products. These are results of actual cases. There's been a significant problem with inventory, with stock held in other people's businesses. Assets hired, leased or stored on someone else's property. Machines owned by one company and hired to another company within the same group. Amazing as it may sound, but that cost the owners of the equipment about $2.4 million in equipment that was lost. A cabinet maker was caught by a preferential payment demand by a liquidator. Preferential payment claims are one of the biggest problems under this legislation. So potentially every tradie, subcontractor, business working for other contractors is potentially liable. Considerable costs have been incurred by hiring and renting businesses. There is a significant problem with preferential payments that can affect businesses which are subcontracting to other businesses. You need to be proactive about your risk management. Obtain legal advice on two very important agreements, the Terms of Trade Agreement and the Retention of Title Agreement. You might need more than one configuration of each of these agreements depending on your business activities. It's also important that you have a frank discussion with your commercial solicitor and advise him or her on what your business does so that they can draft the agreements to give you some protection. But that's only the start. You then need to install systems. And in my experience, most legal firms don't get involved in the establishment of systems for small, medium enterprises. They basically leave that for accountants or business advisors to attend to. So you need to have had a discussion with your accountant to ensure that you have an appropriate system put in place. This is a comment from a liquidator, Darren Vardy, who participated in a webinar that we conducted for accountants a couple of years ago. And he sent me this note and gave us permission to use it. As an insolvency practitioner, quite often we are faced with suppliers who have retention of title clauses, RMAPA, in place, but are not aware of the changes in the security regime effective in January 2012. This lack of awareness amazes me and is predominant amongst small businesses. Unfortunately, the business owner generally finds out the hard way when faced with an insolvency practitioner who tells them that they no longer have the title and or ownership of goods. Now, this has occurred because your customer or the business that is holding your assets has had a liquidator, receiver, or trustee in bankruptcy appointed. It's really nothing to do with you. And in making these comments on the Personal Property Securities Register, I'm not necessarily defending this legislation. I think it's got a lot of problems, but it is the law, and the courts are administering the law. Our legislation is based on New Zealand's legislation, which they've had for about 5 or 6 years longer than us, and they in turn copied individual provinces in Canada, or based their legislation on individual provinces in Canada. So when is the time to act? It's now. The legislation's been running since January 2012. If you haven't been caught under this legislation at this stage, congratulations, that's great. But I don't know if your luck's going to continue forever. So you need to start somewhere, and I really suggest that should be now. Because a transaction that you enter in today could cause you significant problems through an insolvency event. Nothing to do with you, as I explained just a moment ago, but the people you're dealing with. So you need to get into the habit of having a system that enables you to decide whether the potential financial risk posed by a customer requires a registration to be made on the Personal Property Securities Register. So if you're supplying inventory, so you're selling stock to someone to get protection under the legislation, that transaction must be registered before the grantor obtains possession of the stock. Not 6 weeks later, before, is what the legislation says. And if it's not inventory, it's got to be registered within 15 days of the grantor obtaining possession of whatever it is. 15 days. It's not long. And other security interests, which could be a range of matters, even including intellectual property that you've assigned to someone else that they can use in their business. Those agreements must be registered within 20 days of the agreement. And this is why you need a system to ensure that these things are functioning properly. Let's have a look at the 9 myths that we've assembled that some people think are right, but they're not. The cost is not tens of thousands of dollars. In fact, you can register a company, a transaction, for 7 years for $6.40. Admittedly, there are some costs within your office, but it's part of business operations. Some people have argued this is only an issue for large companies. Unfortunately, there are thousands of Australian small businesses that have been caught up through ignorance of this legislation, and it's cost them dearly. In fact, some people have lost their businesses. The myth is that registration on the register is very complicated and time-consuming. It's not, but you need to follow through the system appropriately. We don't have assets at other businesses, so the PPSA doesn't affect us. If you're contracting with someone else, you're a subcontractor contracting with someone else, you're potentially liable to a liquidator's preferential payment claim. So you don't have to have physical assets, but there are plenty of other ways you can get caught under this legislation. You need terms of trade agreements and retention of title clauses, because you cannot get an effective protection under this legislation unless you have those, and they have been signed by your customers and returned to you so that your employees can process the registration on the PPSR within the very strict time limits. This is why you need a system. If it was important, the government would have conducted an education program. Well, unfortunately, the government did conduct education programs in the lead up to January 2012. I don't think they promoted them anywhere near as well as they should have. They were poorly attended all around Australia. There has been an inquiry into this legislation and the government has been criticised for the way the education programs were presented. But nevertheless, the government's attitude is this legislation is in place. Doesn't really matter. We're selling the business in 12 months. Well, you could have real problems by then if you have not registered transactions. It's not a beat up. The fuss will die down. It'll only die down when Australian businesses are fully aware of the quicksand effect of this legislation and ensure that systems have been implemented to protect your business assets. You can't plead ignorance. The courts have been very definite in that. There was a 2-year trial implementation period. That's well and truly passed. And the courts are interpreting this legislation strictly in accordance with the legislation. So that's the 9 myths. If you're interested on ESS Small Business, we have some free material on Personal Property Securities Register, and we also have some paid articles that if you wish to obtain them, you will need to process that purchase through the shopping cart. If you want some assistance in this area, you could visit the ESS Small Business website and log on to Find an Accountant Advisor. And all you need to do then is enter your postcode, no names, no telephone numbers, and you will be able to obtain names of accountants in or near your postcode who are committed to providing a Personal Property Securities Register system for businesses like yours. And then it's up to you to make contact with those accountants, business advisors. They will not contact you because they don't know who you are. You can visit the ESS Small Business website to get free articles on a wide range of matters, not just on the Personal Property Securities Register, and there are also paid articles. And there's promotions by various experts on a range of matters: sales, marketing, Fair Work Australia deliberations, workplace health and safety, debtors management, budgeting, cash flow forecasts, that we are presenting free webinars featuring these people on an ongoing basis throughout the years. Thank you for your interest in reviewing the Personal Property Securities Register. If you are in business and you have not implemented systems for the PPSR, I would urge you to discuss this with your accountant or one of the accountants that you can access on the ESS Small Business website, and then have a meeting with your legal advisor, your commercial legal advisor, as soon as possible to get your system and documentation in place. Have a great day. Goodbye.